We're going to go ahead and get going. All right. We're going to go ahead and get going for Lawyer Horror Stories. I'm your host, Boozy Badger. You will notice that the past couple years I've done this, I've tended to have another gentleman up here with me by the name of Mark Whipple. Mark is a Chicago area trademark attorney. Mark left his firm and started his own firm last year. We wish him a lot of luck. However, it is Friday, it is a court day, and Mark is in court today, so he will not be here. Okay? So if you had trademark or copyright questions or questions about the practice of that, you're shit out of luck. You're stuck with me.
But you had a lot.
Before we start the panel, I do need to ask, is there anyone under the age of 18 in the room? Okay. I have to ask because while this is an all ages panel, under the age of 18 kind of dictates what stories I can and cannot tell in the question. So here's how this works. This is Lawyer Horror Stories.
You have his.
This is Lawyer Horror Stories. I'm your host, Boozy Badger. I'm a licensed attorney in the Commonwealth of Pennsylvania, the federal courts in Pennsylvania. We did this earlier. If you missed everywhere I'm licensed, here's the gist of it. I'm licensed in Pennsylvania. Things that this panel is not. It is not a legal advice panel. If you ask me a question for legal advice, I will glare at you. Do not say, well, my friend wants to know what would happen in this situation because A, I know you don't have any friends. And B, I know it's you. Do not ask hypotheticals. Hypothetically, we all know you did it. This panel is not legal advice in any way, shape, or form. It is an informational, educational, and entertainment panel regarding the practice of law and any questions you may have thereof. All right? The way that we tend to do this is I just go to you all, I let you ask questions, I will ramble on. In response, I will likely tell a story. By the end of it, you will believe I have answered your question whether or not I have. If you traumatize me, it will be very apparent you have traumatized me. That said, let's open up the floor. Yes?
Do you have a favorite example of fruit from a poison tree?
Fruit from a poison tree? No, because my clients are morons. I had a case. And you laugh, but no. Smart people don't become criminals very often. And most crime is not like a criminal mastermind, okay? Nobody's Al Capone out there organizing this stuff.
Except for Al Capone.
Most criminals are morons. I had a client a couple years back who got stopped for drug driving. And they got stopped and they called me and I said, oh yeah, I can probably handle that. And I contacted the district attorney. And I said, hey, you got one of my people? And they said, oh, you're on that? I said, yeah. And they said, okay, hold on. And they sent me over their entire file, which never fucking happens. They do have to give me their file, by the way. Just to let you know, the DA doesn't just get to keep crap from us. In criminal proceedings, there is a discovery rule where the DA has to provide me with evidence they plan to use at trial. I never get it before the arraignment. Because the arraignment's generally after arraignment is when they have to give it to me. Right? So I never get it before arraignment because DAs are assholes. I mean, I'm just throwing it out there. They know 9 times out of 10 what they're going to use, but they don't want me to know until after they're arraigned because a lot of those low-level cases I'll plead out before the preliminary hearing, which in Pennsylvania, a preliminary hearing is where the district attorney has to make what we call a prima facie showing in front of the magistrate that they have enough to support a criminal case. Not they have to prove it. They don't have to prove you did. They don't have to, but just evidence that there was enough to support them bringing a charge. Okay? It's a very abbreviated proceeding. But a lot of times the DA won't give me the file before the arraignment. They're not required to. So when I called the DA, I said, hey, I'm in on this one. And the DA is like, hey, yeah, let me send you the file. That's when your oh shit light starts going off. I popped in the dash cam video.
Oh no!
And they sent it to me. I put it in. I brought it because they have a proprietary dash cam video player. Believe it or not, it's amazing. I'm watching it. It's like a 2-hour-long video, so I'm getting popcorn and shit. I locked my office door. I turned the lights down. Just a nice romantic evening, me and my superiority. I turned it on, and I had the officer go up to the car in that video, and the officer says, "I smell the odor of marijuana. Do you have any in the vehicle with you?" If you were here for the last panel, you know my opinion on the police and their ability to smell marijuana. It's always based on my knowledge and training. I identified the odor of burnt marijuana. And you're like, based on your knowledge and training, you can identify the odor of burnt marijuana from like 5 states away. So it's amazing how that works, Superman. But my client, clear as day, on the dash cam video, when they said that, said, "Oh, no, I don't have any in the car. It's all in the trunk."
Okay.
And that's when I hit the stop button. So no, you don't get a lot of fruit and poisonous trees argument. To be honest, you look almost immediately when it comes in, especially if you deal with certain areas, like if you do a bunch of DUIs. You know a lot of the officers at the small departments and even the bigger departments who are doing a lot of DUI work. Because they're always on the same shift, they're always in the same areas, and you can judge based on the name on the police report how difficult it would be to even make that argument. There's several troopers in my area where if I see their name on a police report, I'll just tell them there's not going to be any argument here. We know this guy, and we know he did it by the book because he always does it by the book. Now, I'm going to watch everything, and I'm going to look at everything, and I'm going to try to identify everything. But we're pretty certain that they did this one by the book on it. Secondly, fruit and poisonous tree arguments are very hard to win anymore. It has been limited significantly by the Supreme Court. There's like the eventual discovery rule, which is like, even though you got it illegally, if you would have found it anyways in the normal course of your investigation, we're still going to allow it. So they're very, very hard to win. Most motions to suppress that I have brought or that I have seen brought that have won are based on the timing of an interrogatory question by the police to somebody, and they're very, very rarely going to be mistimed like that. Next question? Yes?
Least favorite type of client?
Oh, I love them. Yeah, I mean, that's the first thing. My least favorite type of client, the one who's not paying me. Before I left for this convention, I had a client who had an invoice outstanding for a few weeks. And trust me, I send you an invoice, and like I'm very clear, you have till the end of the month to pay me. It's that simple. I don't let you get behind on your bill to me. That's, and I had a client who had fallen significantly behind on their invoice, and they've been dodging me for a couple weeks, and then they sent me an email like, "I'm at Disney," and I'm like, "Oh, you can afford Disney." And I'm on the way here the other night, and my email goes off, and I look at it, and the client had sent an email that said, "I am back from Disney. What is the status on my case?" And I sent them a response that said, "Hope you had a good time at Disney. What is the status on my invoice?"
Yep.
And we confirmed this morning that the invoice has now been paid. The client sent me an email that said, "Okay, I paid the invoice. What is the status on my case?" And I said, "I'm sorry. I'm at Discount Disney until Tuesday." So we'll talk when I get back. Honestly, it's not the client that I hate, but it's the area. I hate family law. I do it, but I hate it because no one's ever happy in family law. My general opinion of it, it's something I heard from a law professor when I was in law school, and it has proven true. It doesn't matter what the situation is. If you are doing divorce or custody work, your client is never going to be happy at the end of the day, because what they really want, what they want more than anything in the world, is to not be in that situation in the first place. They want whatever happened to not have happened. And I mean, like when I say that, when I say whatever happened, I mean, like sometimes like, I wish I had never gotten married. But what they really want at the end of the day is whatever put them in that situation, whatever happened, an affair, a drinking problem, a drug problem, abuse, whatever it is, or just falling out of love, they want it to have not happened at all. And you can't give them that, and they will blame you. With family cases, and this, it's kind of telling, my retainer is normally about $4,000 to $5,000, even if I think your case is relatively simple, because I know my last bill will never be paid. I know my last invoice to you will never be paid, because you will never be happy at the end of your case, because what you really want is to not be in that situation, period. And I do have criminal cases as well. My retainer is normally upfront very large, because unless I get you off scot-free, you will never be happy with the outcome of your case. So, next question. Yeah, all the way to the back.
Have you ever had a client who does something and there's sort of like this, what was the plan? So imagine like, you just I walked up to somebody and I just punched him in the face. And you gotta be like, well, why? What was the plan? What was the payout? Or I rob a store and it's like, okay, you robbed the store. What was your plan to get out? Did you have a getaway driver? What was the plan?
The question is, when my clients do something stupid, do I then sit there and go, what the hell were you thinking? Like I want to? I don't. Because the general idea, especially in criminal work, is I don't give a shit whether you did it or not. That's not my job. I care, did you do it? But a lot of times I'm like, don't tell me if you did it. I don't want to know. Right? I don't want to know, first of all, because it may limit my options in your defense. I cannot allow testimony to be presented if I know it's wrong, and I cannot make an argument that I know is 100% incorrect. I have a duty of candor to the tribunal as well as the representation of my client. Number two, like there's no point, because 9 times out of 10 they're like, oh. You know? Man, what did you think would happen when you started a bonfire with Roman candles in the middle of that church? I wasn't thinking. Or my favorite one, I was high. I hear that more than you are. Dude, what were you thinking when you got in a fist fight with her grandpa in the alleyway on New Year's? I was drunk, man. No shit. Like, I thought you were going for a really weird Mike Tyson vibe. I'm sorry. Like, yeah, there's no point in asking. Like, now sometimes it is relevant. Like, sometimes I will say, if you know, like, I've had clients come in, and especially in criminal matters, and they're like, so do you think you're going to get me off? And I'm like, no. No, look, you are fucked. The question is not, can I unfuck you? Because you will never be unfucked. You are fucked yesterday, you are fucked today, you will be fucked tomorrow. The question is, can I fuck you a little less? And in those situations, I may ask, what the hell were you thinking? Or walk me through your thought process, because that's where you try to mitigate. That's where you try to find out the thought process. Because there's some thought process, like, you know, what was going through your mind when you stole that car? I mean, nothing really, man. I'd lost my mom the day before, and that was the type of car she always wanted, and I just saw it and something came over. You know, that's stuff that I may be able to use to mitigate. You know, Your Honor, when considering sentencing, please keep in mind this is not only a first offender, but when they were acting under extreme emotional turmoil based on the recent death of their mother, and were influenced by that. You know, those are things I may use to try to lessen it. But generally, I don't want to know. I don't want to know if you did it. And I have plenty of clients who are like, you know, well, when I was doing it, I'm like, don't finish the fucking sentence. I don't want to know. I don't care. It doesn't matter to me. And that sounds mercenary as hell, and it is. I don't care. My job is not to, like, truth, justice, in the American way. My job is to zealously represent my client. Now, that is not to say that I will take anybody, no matter what, who walks into my office. There's plenty of people where I have sat down, looked at, and said, morally, I find you repugnant. And what is stopping my representation is I find you so repugnant that I am personally unsure of whether or not I can trust myself to represent you to the best of my ability. That's not a failure of the client, by the way. That's a failure of the lawyer. But one of our duties is you zealously represent your clients. Our code of ethics actually states that the representation portion is not an endorsement of their views or actions to ensure that the two that I steadfastly will refuse to represent simply because I do not trust myself. And it is frank, I do not trust myself to zealously represent them. Child molesters and heroin dealers. I do not trust myself in those situations. They need a representation though, because that's how the system works. Everybody gets a defense. And if you don't hold the state to the standard to prove it, then the system falls apart. If the assumption with everybody that walks into court is they have been charged with a heinous thing, so they should not get a defense, that is a horrible system. That is a system that puts a lot of people in jail without requiring the state to prove it. And as that goes forward, it becomes a little more lackluster and a little more lackluster and a little more lackluster. And suddenly you have people who have to prove that they are innocent instead of the state having to prove they are guilty. And God help you if you ever get on the wrong side of one of those systems. Next question? Yes.
You think about legal insurance, like A-Rods?
Mike,
What was the question? I couldn't hear.
what do you think about legal insurance? Like, do you know what legal insurance is, everybody? All right, there are some programs you can buy, and it's like regular insurance, except if you get into a legal case, they will find you an attorney and pay for that attorney. From a consumer perspective, read those policies. A lot of those policies have very significant restrictions on what they will and will not cover. A lot of litigation types are not covered by those policies. Like they're like, yeah, we'll help with the divorce, but if custody becomes an issue, that's not covered by our insurance and you need to negotiate the rate separately. Yeah, well, but we won't cover a criminal defense matter. We won't cover intentional torts, so if you hit someone with your car. Things like, we won't cover any of that. Read those policies. For day-to-day stuff, it's good, I guess. It never hurts to be able to say, I have a contract I want reviewed, and I have legal insurance so I can get an attorney to review it. I will say in my general experience, this is not a slam on the guys who do it. I don't accept it. I refuse to sign up with any of them. They negotiate their rates at far, far below what I normally charge hourly. So my payment to them could be less than half of my normal hourly rate. That's what they may pay me. You make your money off of volume on them. I have a lot of cases, but I have a small practice. Our practice is 2 men. The legal partnership I'm in, it's the 2 of us and that's it. So I don't need 200 cases sitting on my desk that I have to go through because of legal insurance. The third thing, and this is something I have noticed with the guys who do it, who do take that, they almost always are taking them on volume. They're almost always taking them at a loss. If another case comes in that you can bill full rate for, at the same time they're handling your case is not on top of the pile. Your case is in the pile. Like, we're not going to miss your deadlines, but I'm also not going to spend a lot of time talking to you. Because if I'm getting $75 an hour for it, and after I take out the firm overhead and everything like that, I'm getting really like $15 an hour for your case, you're not on the top of my concern list. I'm not going to miss your deadlines. I'm going to appear in court. I'm going to represent you. But if you want something explained to you and you call the office, I'm going to be like, send me an email. I'll get around to it. So it really depends. But it can be a good idea. I mean, it really can. A lot of your day-to-day general stuff, traffic tickets a lot of times, contracts, bankruptcy, things like that. Like your day-to-day legal stuff, the stuff everybody's going to encounter at some point, it can be a really good idea to have. If you're buying it against being sued for massive amounts of money, you got to read it carefully. A lot of those policies will not cover that. Personally, I don't take them because they don't make financial sense for my office to take, though. Yes, any other question? Yeah.
What's the dumbest case you've ever had to fight? I'm sorry. You have to have one of those stories like, oh.
I have to just sit up here quietly for the next half hour. You have to fight stupid cases all the time. I mean, here's the thing. In Pennsylvania, we do not have a small claims court. We have the magistrate's court, which that's what we call a lay judiciary. And a lay judiciary is your judges have no legal training. They're an elected position. Each county may have like my county has 9 magistrates courts, and they're based on areas around the county, and the magistrate sits there, and the magistrate is empowered to hear any case up to $12,000. The way they spend it is it's like a grassroots court, but the judge is not necessarily going to have any legal training, so there is always an automatic right of appeal from the magistrate's court to the court of common pleas, or as I say, and video or not, I will deny this till the end of the days. If you ever tell a magistrate judge I said it, the real court. Where every judge is required to have legal training. Okay, that is like the trial court. When you think court, that is the court of common pleas in Pennsylvania. The thing is in areas that have like a small claims court, it's generally, this amount below, that goes to small claims, and the process is a lot like our magistrate. In Pennsylvania, the magistrate court is optional. So the magistrate can hear a claim up to $12,000, but I don't have to bring it in front of the magistrate. If somebody comes into me and they go, I want to sue Bob for $100, I can put it in front of the court of common pleas. Now, you don't get a jury trial because jury trials are restricted in Pennsylvania a lot of times. But I can put it in front of the court of common pleas, and I can put it through the entire process. I mean, I can stick it in there. I'll file a complaint. You have to file an answer. We'll have discovery. I can take depositions. I can drag that $100 claim out for like a year or more. You don't even get a trial originally. You have to go to arbitrators because it's below $50,000. It's a county-by-county thing up there. In my county, the limit for mandatory arbitration is it has to be above $50,000. So you have to go to arbitrators. Arbitrators are 3 lawyers who hear it in like a mini trial. Like I'm an arbitrator. I'm trained as an arbitrator in my county. And we make the determination, and then you can appeal from that determination up to the trial court, and then that's where you get a real trial. So in theory, if I wanted to be a dick and you sued my client for $100 and you sued him in front of the magistrate found for you, I could then appeal that to the court of common pleas, and you have to file a complaint in front of the court of common pleas, and I can drag it out for a year or more and submit to arbitration mandatorily through that. And then we get an arbitrator, and we have a half-day trial, and then within 10 days I can appeal that arbitration decision, and we have to go on the judge's trial list. I get 3 trials on one fucking issue, over $100. And I can have somebody direct me to hold 3 trials on one issue, over $100. To the extent that by the time we're done, they paid like 100 fucking times in legal fees what they're going to collect, because it is a matter of principle. In case you have not guessed, I'm not picking the number $100 out of thin air. Principles are expensive. And I'll tell clients that all the time. When they come in, they're like, it's a matter of principle. I'm like, principles cost a lot of fucking money. You understand this, right? I'm like, if you have a few less principles, I can do it for like $3,500 and get it settled. If you have principles, do you have equity in your house? Because I know a guy and he can refinance you. Now, I'll have people like that, though. I'll have well-heeled clients who it is a matter of principle for them, and they do not care. If they could just pay $100 and make it all end, And I don't care, and I'm not going to give them the damn 100. I didn't break their computer, and I got enough money to pay you, Mr. Tabler, to take it all the way to the end if we need to. And if they appeal that ruling, if they find a reason to put us in front of the Superior Court on an appellate matter, I'll pay you to fight the appeal. And if the judge rules against me, I'll pay you to appeal it. I'm like, you're talking like 6 figures, over $100. And he's like, fuck them, I got the money. I mean, I have a client who has done something close to that. I can't say exactly to that, but those are cases that I've handled. Our principal guy. I have one client who was a material man for contractors, and they were so big on the principle that he had a saying: bankruptcy or blood. He would file, if you didn't pay his company, he would instruct us to file a lawsuit and to push the lawsuit all the way through to the end of the day, no matter the cost. And he wouldn't settle for anything less than the full amount of his invoice. And that's what we tell him. He will take his invoice. He will eat the attorney's fees. If you pay him his invoice, we're done. And his opinion was bankruptcy or blood. I either want him to, I don't care if I spend $100,000 to collect on this $25,000, and at the end of the day, they file bankruptcy. I'll put them out of business, or I will get my money. And it sounds ridiculous to do that, right? Except contractors, by and large, have a really bad habit of stiffing their suppliers, knowing that if you sue them, they can settle for like 1/3 of the invoice. You know what ended up happening? My guys, I can't go into details on who he is, but it's not an insignificant company in the area and type of material they supply. I would say it's one of the larger ones in that area in the state. The word got around that if you stiffed my client on an invoice, that you would meet me very soon, and that within a year and a half, you would either have paid the invoice or gone out of business. And my guy gets paid on his invoices in a timely manner now, specifically because of bankruptcy or blood. So, principles are expensive, but sometimes they have a purpose. Yes?
When you're suing somebody, you're having a situation like that, can't you tack on, like reasonable court fees to...
You just asked a question that I get from every single one of my clients, which is, what about your fees? Who's paying your fees? Okay, so quick primer, because I want to dispel this notion that you always get your lawyer's fees. There are two systems. There's the American model, and there's the non-American model. The non-American model is a loser pays system, okay? That is, if you win, then your reasonable court costs and attorney's fees will be covered by the losing party. It's almost an automatic thing. That's the system they use in most countries, believe it or not. The American model is you pay your own goddamn lawyer. Unless a statute, a law, specifically authorizes the collection of attorney's fees from the losing party, or you have contractually agreed with the losing party, or in some circumstances, it is so clearly a matter of malfeasance, which is did something bad, that it's allowed, which generally, like fraud, there's common law principles saying you can get your attorney's fees back. But that's really the only bigger one that you can think of. Then the person who hires the lawyer pays the lawyer. That's just how it works. Court costs you can generally get back a lot of times. That's not uncommon, but attorney's fees, not unless one of those circumstances apply. And I'll tell my clients that right off the bat, is unless one of these circumstances apply, don't ask for attorney's fees, because we're not going to get them and I'm not going to make the claim. It seems kind of strange, and it's going to seem even stranger when you think about why. Okay? Back when they were making the decision, the reason it's called the American model, back at the founding of our country, that developed because they felt that otherwise, if you made only the loser pay, it would prevent access to justice. People wouldn't bring lawsuits that they weren't absolutely certain they could win because they didn't want to have to pay for the other guy's attorney and their attorney. Okay? It seems like that's backwards, right? But let me ask you, if your landlord evicts you, and you go and your landlord has 10 times the resources you do, and you go to a lawyer and that lawyer says, because just because the loser's paying doesn't mean I'm not getting paid too. All right, and you're paying me, you're just getting reimbursement from them for whatever the reasonable amount is. That's how it works. It's not, I'll only collect if you win. That's contingency. I don't do that. A lot of lawyers won't do that. And even in the countries that do the loser pay system, you're still paying your lawyer. You're just able to get it back from the other guy. Okay? Would you outlay the money to hire me over a matter with your landlord if you know that your landlord is going to, A, have a much better attorney? When I say much better, I shouldn't even say better, but have a much bigger attorney. Somebody who is charging much more and can justify a higher rate because of their size and the number of that specific type of case they do. And I looked at you and I said, it's a question. Well, then that's 90% of the time people come to my office, well, I'm going to win, right? I'm like, I don't guarantee that. No lawyer guarantees that. Any lawyer who is guaranteeing that they will win your case is lying to you, because I've been doing this long enough to know you can't predict that. I think you have a very strong case, but I'm not going to guarantee you're going to win it. And I've gone as far as to say if an attorney guarantees they'll win your case, that's malpractice. They shouldn't tell you that. I've done this long enough, and I've been in front of enough judges and enough juries to know you can't guarantee that. Okay? I think you could have the best case in the world, but a jury could get hung up on one fact of it and find against you. A judge in the middle of the case, the state Supreme Court could find the exact opposite way in a case under the exact same circumstances, and the judge would go, well, based on this case that just came down, I can't rule for your client. No one's going to guarantee that. But if I said, I think you have a good case, but most cases, I'm just saying, most cases when people ask, what are our odds, I go 50-50. It's always 50-50. Until I get in discovery, I think it's 50-50. If a lawyer said, I think you got a 50-50 chance of winning, but I believe you have a strong claim that we can bring, and a lot's going to depend on what shows up in the discovery process and what they can claim as defenses, I would expect X, Y, and Z. Here's how I would generally respond to X, Y, and Z, and all that. But if I said, I think you'll probably win, but it's 60-40 right now without me doing discovery. By the way, is where I get everything they're going to present at trial, and they get everything I'm going to present at trial. That's a whole process. But until we're in discovery, I can't really say right off the bat on it. And you knew that if you lost, not only did you have to pay me, but now you've got to reimburse the landlord for their lawyer. Would you be likely to file that case? Not unless it's a lot of money, right? So the idea of everybody carries their own bill was actually meant to remove that from the calculation. You sit down with me, Mr. Tabler, how much do you charge? And I tell you how much I charge an hour, and I give you estimates of where we may be, and going in that unless they are suing you under something that would allow for attorney's fees, a specific set of circumstances that would allow for attorney's fees, where you are, maybe you do bring that claim. Maybe you are entitled to seek that relief, and you have an idea of how much it's going to cost to get there. You also have to understand the billable hour, the idea, an attorney saying I charge $300 an hour. That is a relatively recent development in law. It really did used to be. You would ask, how much do you charge for X type of case, and I would tell you how much I charged for that type of case. It wasn't based on the hour. That is a relatively recent development. Now, don't get me wrong, I use it, but that is relatively recent. So, yes.
Have you ever had a case where you were certain of the outcome, or at least felt very, very confident of the outcome, and it went spectacularly wrong?
I mean, I've had ones that went spectacularly right.
That too.
Actually, yeah. One of my first trials, I had a client who had been discharged from their employer under a certain set of conditions. And the story I got from them, I came in like 2 days before. Yeah, I shouldn't say trial, it was an administrative trial, which means it's not a full court, but one of my first appearances in a proceeding, I should say, as an attorney. And I got in their facts, and nothing from the other side had made me think it, and I had them in, and I prepped them for the hearing, and we went through everything, and I kept telling them, if there's anything you're not telling me, I need to know now. And they said, no, there's not. And then we got into the hearing, and there was a lot they needed to tell me. I remember we walked out, and they looked at me, and they said, how do you think that went? And I said, well, and they said, do you think I'll get my job back? And I just started laughing. And since then, I have told every client the same thing, which is, I am your lawyer. I don't care what you're doing. Okay, it's not my job to judge you. I do not care. I genuinely don't. Are you accused of like tossing your fucking grandmother into a tub of electric eels? Okay, if I ask, did you toss your grandmother into a tub of electric eels? You need to say yes. You need to tell me that, because I need to know that. If I don't ask it, I probably don't want to know it. So don't just answer the question. But if I ask it, I definitely want to know it. Okay? I'll have clients who are like, well, I don't want to tell you about that. I don't want to tell you this. I don't want to tell you this. And I'm going, if I'm asking, I need to know. And you know why I need to know? Because if I'm asking it, they're going to ask it. And I know how you're going to answer it. Because I can fix just about anything. I mean, not to toot my own horn, I'm good at what I do. And guys, before I left here, I had a court hearing on a very large matter where there's a contract at issue, and when the other attorney started going off on all this other stuff, I stood up with his witness after he was done. I said, okay, so back to the issue at hand today, though. Where in this contract does it say that position? Well, I guess it doesn't. You know other people in your field have contracts. Yeah. Have you reviewed those as part of your years of experience? Yeah. All of them have that in their contract, don't they? Yeah. Why don't you have it in yours? Don't know. Do you believe they should be bound by a term that you guys just didn't put in your contract? No. I got nothing further, and set my ass down. Because it's not about us. Sometimes it's just in and out. Do your job very well and get it done with. All right? I kind of forgot what I was answering. That's things that. But I'll tell clients, there's very little I can't fix if I know about it in advance. If the first time I hear about something is sitting in the courtroom with the judge listening to you, you're fucked. It doesn't matter how well I dance after that point, it's not going to be good. Okay? Those are the situations where my clients shoot themselves in the foot. Is I'll ask a specific question and either A, they lie to me, and when they lie big. I mean, it's never like they omit the fact it was a Tuesday, not a Tuesday morning, not a Tuesday night, or they were in a blue shirt, not a red shirt. I mean, it's like omitting the fact that, they own a gun of the same caliber used in the shooting that they purchased 2 days before from a pawn shop or shit like that. That's what it is. Those are the lies they tell. And those are the ones that you then find out in court and you're looking at them like, well, you're fucked. The sad thing is that I'll not only say, can I probably fix it or at least limit the damage if I know about it in advance, but I can't do anything about the damage. This one will drive people home, especially in criminal trials. When I'm like, I said, look, end of the day, let me tell you my stake in all this. I'm your lawyer. I will zealously represent you to the end of the earth. I will fight for you. I will advocate for you. We will have a wonderful trial, and I will do everything I can. But end of the fucking day, whether you go to jail or not, you know what I'm doing? I'm going home. So if you want to lie to me, only thing it affects on my end is my win-loss record. I would suggest you don't lie to me. Because the only person you're hurting is yourself. I still have your money, and I'm going home that night. Yes?
What is the strangest case you've ever had to deal with that you think would make for a good segment on, say, True TV?
How many people in here know about the poop?
The what?
Not enough.
Well, that's all the time we
There is something called attorney file retention. What that means is anything that comes into my possession during the course of representation, I have to maintain either the original or a duplicate in my file for a certain number of years after the end of representation before I can destroy it. Now, I get to destroy this file soon. But when I first started at the office I'm with, a person came in, they had hired a contractor, and the contractor had not completed the work, and we were bringing a lawsuit, and amongst the several things that the contractor had done, the accusation in part was that they had taken a shit on her floor. So of course I scheduled the meeting. And they came in, they went through everything, and they go, and then they shit on the floor. Would you like to see pictures? And I'm like, whoa, wait. You brought pictures of the poop? It's like, well, yes, otherwise they could argue it was dog poop. And I'm like, okay. So they brought out the pictures, and I'm like expecting grainy iPhone photographs that they took up to Walmart and got printed out. You know what I'm talking about? No, like these were professional quality with that. Like I wondered if maybe they had airbrushed some corn kernels out of it or something. These were nice shots. Like if you put a fox head on the poop, it would have been a person photo. I'm just telling you, that's how we were going here. So I review the photos and I go, okay, well, these are very telling. You have a wonderful artistic eye, by the way. What rig did you use to shoot this? So I hired one of the high school portrait people. But I said, okay, well, you know, these will be very, very helpful. And she goes, and they could DNA test it. Well, and I looked at her and I said, what do you mean they could DNA test it? And she goes, well, I kept it. And I'm like,
Did it win?
pardon me? I kept it. And how did you keep it? In Tupperware so it stays moist. Oh, God. Would you like to see it? To which I said, you brought the poop. They had indeed, it was in the car. So now I had the poop. I ended up taking that case. We ended up deposing the contractor. And during the course of his deposition, I inquired about whether or not he had defecated on the floor. And the contractor advised me that he did not, and I said, well, would that remain your answer if I could produce the poop? And he looked at me very strangely, and then I pulled out the Tupperware container. We ended up settling that case. I remember what I said at the beginning, that I am required by my ethics rules to maintain any material matter that comes into my possession during the course of representation. I am not exactly sure how I would have made a copy of the poop, but I was willing to learn sculpting. If my client would agree to come and pick up their original, so I only had to keep copies in my file. However, my client, like most clients, received their check and didn't really give a shit after that point.
Do you still have it?
The poop is now in my filing cabinet in my office in a green Tupperware container. It has been there for almost 4 years. Which means at the end of this summer, I get to destroy the poop. And somebody in the back said, does it turn white? And guys, I got some news for you. Tupperware really does keep stuff fresh. I would like to point out that I'm glad I haven't had to burp that container, though. We have time for one more question. Yes?
Fecal matter notwithstanding, what is something that no amount of law school in your experience could prepare?
No amount of law school prepares you for? Oh, we were having such a nice time. This is not a funny story, and I'm just going to warn you in advance. You know how earlier I said that I have two types of people I do not represent.
Yep.
Okay. They are child molesters and heroin dealers. I don't represent heroin dealers because my younger cousin, 15 years ago now, overdosed on heroin and died. And the person who sold him the heroin knew he had a heroin addiction, knew that he was trying to get clean, and presented themselves as a friend to get him to keep buying the heroin. And that's how my cousin died. And in my opinion, I do not trust myself to represent heroin dealers. Child molesters, you would think would be obvious because I have kids, right? I have represented child molesters in the past, accused child molesters in the past. I do not, because I was involved in one case and I saw the evidence that was being presented in that case. And I like to think I have a strong stomach. My stomach was not that strong. There is nothing that they use to prepare you for that. Not only that, remember what my job is. I'm not a prosecutor. So when the prosecutor provided their evidence to me, and I reviewed what can best be described as a photo album that had a very recognizable face in it, a face that I was very familiar with, because it was a face that would come into my office once a week and sit down across from me for me to tell him how his case was going. And it was somebody that you wouldn't know them, obviously, but someone that you would not think that of. I continue to represent that person after seeing that. And law school does not prepare you for that. It does not prepare you for that type of representation. It does not prepare you for talking to people who have done that sort of thing and understanding, hey, they're still my client, and I still have to represent them. And my job is, quite frankly, to try to keep them out of jail. Nothing prepares you for that. It's something that every lawyer experiences. Maybe not to that degree, but that every lawyer experiences at some point in time. Because you're not saying this person's fine, this person's okay, you should let them out, you shouldn't put them in jail, they're innocent when you know they're guilty, or things like that, because you like the guy and you think he should be free to do it again. You're saying it because that is the way our system has developed, that is the burden that is placed upon the state, and that is the burden, quite frankly, that is placed upon the defense attorney to force the state to prove its case, because if you do not, then the system doesn't work, and yeah, it means some shitheads will go free. I mean, genuinely, it means some horrible people will walk out of the courthouse. Okay? It also means some people who didn't do anything and are being accused wrongfully won't go to prison. And in our system, that's what we put the emphasis on. The people who are accused and shouldn't go to jail, not the people who are guilty and don't go to jail. There's something called Blackstone's ratio. William Blackstone was a legal commentator in England who wrote down what is probably the first collection of jurisprudence. And Blackstone's ratio is, it is better that 10 guilty men go free than one innocent go to jail. And that is the leading light of our criminal justice system. Now, Benjamin Franklin would later change that. He would paraphrase it. And the way he paraphrased it was not to lessen the ratio, but that in the United States of America, it is better that 100 guilty men go free than one innocent man go to jail. So there's plenty of stuff in law school that they don't prepare you for. And that you're never going to be prepared for until you're actually out there practicing law, doing it, and you have to experience. I have been very, very lucky. My father is an attorney as well, granted in another state. So when those days happen, I get to call Dad. And I get to ask Dad, how did you deal with it? Normally he'll tell me. I have friends in the criminal bar, mentors in the criminal bar and the civil bar who've been practicing much, much longer than I have, that I can call when something like that happens, and they'll say, let's go grab a beer. And we sit there and they just let me vent, or they tell me how they've handled it. That is one of the great things about the legal profession, is we very much, despite there being law schools, despite there being a bar exam, we very much have maintained the way that lawyers were created for hundreds of years, which is by being mentored by older and more experienced attorneys who teach you what law school does not. Law school teaches you how to think like a lawyer. The practice of law and mentors teach you how to be a lawyer. So, and with that, I have to be on the convention horror stories panel because my day's just fun. In 3 minutes. So thank you all very much for joining us today. Have a wonderful rest of the con, and I will see you later.
Silver Gattoman, he bought me a coffee. Silver Gattoman, here is the song for thee. He likes to video all the panels at the cons. You should go and watch them whether they are short or long. Silver Gattoman, you video that's not a jibe. All of you go to his YouTube channel and like and subscribe.